Madam, please begin.
Sure, sir.
Yes, sir. Yes, sir. Disha ma'am, am I audible?
Yes, you are.
Disha?
Ambika.
Okay. A very good afternoon to our distinguished speakers and all our guests. It's a great honor for me to welcome you all to the expert talk on the topic Exploring Traditional Knowledge Protection Through IP Regime. At the outset, I would like to express our deep gratitude for your presence in this expert talk. The current system for property was fashioned during the age of industrialization in the West and it was developed subsequently in the line with the perceived needs of the technological advancement of the societies. However, in the recent years, indigenous people, local communities, and governments, mainly the developing countries, have demanded equivalent protection of traditional knowledge systems. In the light of this and a huge outcry for the need of sui generis legislation relating to the traditional knowledge in India, we have with us today two experts who are going to talk upon this topic and discuss further upon it. On this note, I also want to thank our Dean, Dr. Namita Vyas Joshi ma'am, who is helping us throughout and granted us kind permission for organizing this event. I would like to invite our first speaker for today. We have with us Dr. Nidhi Butch ma'am, who is an eminent and acclaimed IPR faculty currently in India. Dr. Nidhi Butch ma'am is currently working as an assistant professor of law at Gujarat National Law University, which is a leading law school in India. She's graduated in economics and pursued her law and obtained LLM with commercial law specialization. She has also completed postgraduate diploma in intellectual property rights. She earned her doctoral degree from Gujarat National Law University in the area of intellectual property rights also. She gained wide experience as a consultant on intellectual property rights with NID Ahmedabad during the year 2001 to 2004. She's also associated with various law schools and management institutes in the capacity of visiting faculty. Being a qualified advocate, she has also worked in the Chamber of Senior Advocate at Gujarat High Court. Ma'am has been associated with Gujarat State Judicial Academy as a visiting faculty and has imparted training to newly recruited judicial magistrates for the state of Gujarat. Moreover, she is in the capacity of Director, Center for Excellence on Intellectual Property Rights at GNLU. She is actively involved in teaching, research, and extensive activities organized by the center along with the three chairs, which is the Microsoft India Chair, Guj Course, and the Research Center of IP Laws and Policy, that is DPIIT Chair of IPR. Ma'am was nominated to be a member of Committee for Drafting IP Policy for the Central University of Gujarat. She also worked for the Education Department, Gujarat, in making IPR policy for universities in Gujarat to support the innovation, startup in academia, etc. She is conferred with the IP Academician Year Award in 2017 as well as 2018 in recognition for her outstanding contribution to the field of IPR and IPPO. She is recently recognized and awarded as one of the 100 powerful IP women in India 2021 by the World IP Forum. Her recent book titled Geographical Indication of Indian Handloom Between Legal Rights and Real Rights is published on December 31st by Routledge Taylor and Francis UK. We are glad to have you, ma'am, and we would like to have your expert comments and expert knowledge over this area.
Thank you very much, Ambika, for that generous introduction. I'm sure that has raised a lot of expectation in the audience. I'll try to do justice to that. Very quickly, without wasting much of time, I'll just share my screen and you can give me a go if that screen is completely visible.
Yes, ma'am.
All right, thank you. So I'll be looking at this particular topic from the lens of geographical indications, being very much aware of the fact that as far as the protection of traditional knowledge is concerned, I think globally, after a lot of debate, there's one thing which is very clear, and that is that traditional knowledge of different countries, especially developing and underdeveloped countries, is required to be protected. Because if that is something that is not protected, then that will definitely cause a lot of socio-cultural, economic disadvantage to those communities, the indigenous community. And that is that is the first realization which is there at the global level. Another, I think, thing which has come out after a lot of research, which is now taking place in this area also. Earlier, before 10 years, if you talk about traditional knowledge, there was almost complete dearth of research, and awareness was also much lower than what it is today among among all stakeholders. So another realization is that traditional knowledge not only is required to be protected, but if sui generis system can be evolved in order to protect traditional knowledge, that can be considered to be the best. Now, what is the way out by the time we are able to come out with a sui generis system? What is the way in which you protect? You cannot let go your traditional knowledge die untimely death. So then what all possibilities are there? And while exploring this, I think there is one eminent form of IP which is now being recognized as a tool for protection of traditional knowledge, that is geographical indications. Of course, there is a disclaimer: the geographical indication per se by itself does not protect the traditional knowledge. It protects the traditional knowledge-based products, maybe due to the climatic or maybe due to the human factor, natural factor or human factor. So it does not directly protect the traditional knowledge, but the product which are based on traditional knowledge are being protected through geographical indication. The scheme of my presentation is I will look at the conceptual analysis of traditional knowledge, but just I'll restrict myself to only the definitional part of it. Then significance of protecting traditional knowledge as far as India is concerned. Then geographical indication, its meaning, its significance, interface between geographical indication and traditional knowledge, and how GI can be considered to be an effective tool of protecting traditional knowledge-based handicrafts and also the agriculture products. And then, of course, the issues and the challenges that we are facing. So looking at the conceptual analysis of traditional knowledge, the most accepted definition that we have got is provided by the WIPO. So traditional knowledge is nothing but a form of knowledge. There are two forms of knowledge that we know now. One is modern, the other one is the traditional. So it is also a form of knowledge, know-how, skills, and practices that are developed, sustained, and passed on from generation to generation, right, within a community. So we are talking about community, we are talking about such kind of knowledge which is passed on from generation to generation. So this very brief, precise and concise definition is providing us an idea. However, if we want to look at the features of TK, right, which are well defined under the Convention on Biodiversity, because biodiversity is also something which is becoming extremely important as far as India is concerned. So traditional knowledge is a kind of knowledge which refers to such innovations and practices of indigenous and local community, right, around the world. So when we talk about traditional knowledge, we definitely cannot separate it from the community rights and indigenous rights, and that is the reason when we talk about protection of traditional knowledge and when we look at the broad spectrum of various forms of IP that we have, one and only form that comes to our mind is geographical indication, because through geographical indication the rights which are granted are collective rights and not personal or individual rights, right? So it is a kind of knowledge which can be, which can take any form. So songs, stories, folklore, cultural values, are we talking about this through protecting through GI? No, that is something which is part of traditional cultural expressions. We are not talking about it. We are talking about traditional knowledge-based products, which can be agricultural products, which can be handlooms, which can be handicrafts. These products and how they can be protected. Again, GI is a very important form because it is not only prescribing for collective rights, it is also at the same time providing for perpetual protection. Because once a GI for in the first instance is protected for 10 years, it can be protected in perpetuity if it is renewed time to time with every 10 years of duration. So in that way, traditional knowledge is something which is very, very important for us to be protected. Looking at this is from the features and the definition. Now, looking at the formal significance, right? So, of course, if we want to look at the significance of protecting TK for India, Why do we want to? Of course, we want to preserve the knowledge. In fact, I'm sure those who are, I precisely did not, touch the aspect of intellectual property, because I assume that the audience is well versed with the IP and its forms. So I'm not looking at it, right? So we all have recognized the significance of preserving the knowledge. But then we definitely have now recognized the significance of protecting and preserving our traditional knowledge as well. Because before a couple of decades, we had very sour kind of experiences in the domain of traditional knowledge, like in case of neem patent, in case of basmati rice, in case of turmeric, in case of tamarind, in case of ashwagandha. So many such kind of products and their usage have been protected in one or the other form in one or the other developed countries. And that is something which actually compel India to think about the protection of traditional knowledge. So not looking at how traditional knowledge is being documented with the help of TKDL, that is Traditional Knowledge Digital Library. Now we are looking at it from a broader perspective of giving it, because that is something which is, which is a defensive way in which you can protect it. We are looking at it from the right that can be legally established, right? So that is documentation when you do not have any form in which it can be protected. But we are through GI looking at a particular form in which TK based products can be protected. It is something which can enable us to participate in global market. Look at Darjeeling tea. That local product has definitely in true sense become global. Right? There are better opportunities for socio-economic developments if we protect our traditional knowledge. It will definitely help us develop our rural areas, because protected traditional knowledge will generate livelihood opportunities. It will definitely then provide benefit sharing opportunities also. So lot of revenue generation potential is hidden if we are trying to come out with a system for adequate protection of traditional knowledge. So protection of traditional knowledge will be and is having this kind of significance. Now, directly I'm looking at GI, right? So look very quickly if I talk about what is GI and the meaning and significance, so that I can now, so how we are going around. So we started our journey with the conceptual analysis of TK. Then we looked at the significance of protection of traditional knowledge for India. And then we are looking at GI because we are looking at GI as a tool for protection of traditional knowledge based products. So what is geographical indication? Geographical indication was once considered to be a sleeping beauty. That is something which is WIPO has also mentioned. So GI was a sleeping beauty. Why? Because it did not have that kind of acceptance as a form of IP. But now it is recognized to be a very vital for the economy of developing and underdeveloped countries. It is considered to be a legal vehicle which can protect and promote the socio-cultural heritage of any community, and especially it has lot of significance for a country like India, where each and every state is a home for diverse cultural values, diverse products and heritage. So product like Darjeeling tea or champagne or Roquefort cheese or Patan Patola or Pochampalli Ikkat or Kota Doria are illustration of geographical indication which are protected products, right? So looking at the formal definition of GI, which is, I'm sure a number of you must have seen this logo also, Atulya Bharat Ki Amulya Nidhi. So invaluable treasure of incredible treasure. So that is something which is given by the government, because the government has also recognized, because if you want to serve a country like India, which is so very diverse, multiple opportunities are required to be created, and there are so many opportunities which are available, and so much of potential is hidden. So how to tap it? So we are trying to tap that potential of our community, which can help them grow socially, economically, and of course culturally also. It can help preserve their values and expressions. So that is how geographical indication is a form of intellectual property that is known to identify product with a particular place. So it is talking about such kind of product which is having unique characteristics which are attributable to its geographical origin. May it be through natural factors like say Darjeeling tea, or may it be through human factors like say for example Kota Doria or Pachal Patola or Kochimpalli, right? It is woven by human and they have created that. So geographical indication is a form of intellectual property which is basically granting community rights to a particular association of producers. Now, what is the rationale of GI protection? Why am I talking about the rationale? Because you will definitely be able to find lot of overlap between the significance of protection of TK and the rationale of protection for GI. So GI definitely can help rural development. Why? Because if there is the association of producers, they are working as far as, or they are weaving something, or say there are on the screen you can see Tangalia artwork, you can see Kutch shawl, you can see Sankheda furniture. All these are from Gujarat, right? So all those who are involved in it, when they are granted with this right, and then they can feed their product to and market their product in a larger market, it will definitely generate better livelihood opportunities, which will definitely help the rural development. Most of the products come from rural area. It will definitely help the customers because it will make quality-based products available. It will recognize those places and it will expand tourism. There will definitely be creation of livelihood and employment opportunities, as I just mentioned. And most importantly, it will help us preserve our cultural heritage and traditional knowledge, and ultimately it will help us lead to achieve the goals of sustainable development. So what is the way in which we protect geographical indications in India? We have come out with a sui generis system, which is outcome of TRIPS, and I'm not going into great detail of how international instruments like Paris Convention, Lisbon, Madrid, and TRIPS have contributed to GI protection system in India. As of now, we have an act, which is 1999, coupled with rules for protection of geographical indication in India. Until date, 417 geographical indications are registered. So for India, geographical indication is not just a legal right. It is something which can become a legal vehicle for rural development. It is a tool for protection of traditional knowledge, and it definitely recognizes a very, very strong and inseparable bond between GI and handloom and handicraft, and also agricultural products. And all these are the products which are traditional knowledge-based products. Now, why am I taking you to the categorical bifurcation of geographical indication tags, for which under which various products are recognized, so that I can then explain how TK is covered and how TK can be better protected as of now with the geographical indication system that we have. So there are 5 different categories for which geographical indication is granted as far as India is concerned, starting with agriculture goods to handloom, handicraft, foodstuff, manufactured goods, and natural products, right? You can see it on the screen on the picture also that I have kept aside the categories. Now, this categorization is internationally not available in form of any international instrument. Even TRIPS does not speak for any bifurcation as far as the categories are concerned. However, we have created it so that we can come out with a better form of protection for our country, which is more suitable, and that is how our system is sui generis system. Now, I'll take you to the category-wise GI registrations. Till date, we have been able to protect 417, right? 2022 March takka data that I am presenting, and the source definitely is the GI registry. This is like, I have just bifurcated them. Otherwise, it is something which is, the data is completely borrowed and taken from the GI registry. If you can see the handicraft and agricultural products, right? Now, handicrafts, which includes textile, handlooms also, and agriculture together are covering most of the GI tags, right? Out of 417, 129 and 231 tags are granted to handicraft, handloom, and agricultural products. And as far as handloom and handicraft are concerned, they are completely traditional knowledge-based products. And agricultural products also have involvement of traditional knowledge. So if we look at, then now I'm sure the audience is convinced that it is very, very suitable for country like India to protect traditional knowledge-based products with the help of geographical indication, right? And why we are saying so? The reasons are this. Number one, there is definitely a strong interface between geographical indication and traditional knowledge, right? Which is something which I'm sure all of you are convinced with. Then geographical indication qualifies under positive protection, right? We are not looking at defensive like TKDL. We are definitely, that is something which can help. But then having positive protection, I'm sure those who come from law background definitely understand the significance of statutory protection. So that kind of protection we can get with the help of geographical indication system, that protection system that we have. Then it is something which strengthens local economic development, which definitely is huge for a country like India, which is so vast. Then geographical indication ensures community right, which is non-transferable, and it also has non-excludability along with perpetual protection. So community right and perpetual protection I have already explained, right? Non-transferable and non-excludable is something but which can be understood with the help of those provisions which are there under the Act, according to which a geographical indication, the rights which are granted under geographical indication are non-transferable. You cannot assign, you cannot license, right? And rightly so, because it's a community right. So if you are granting it as a form of community right, they can't be assigned, they cannot be licensed. So they can be preserved and protected in perpetuity, and that can definitely prove to be much more advantageous. And obviously, if we are able to protect it in this way, it will definitely help us create more innovative and vibrant society. We already have these things, but we are unable to protect. Now, even when we have this, and we are not very new with GI Act, right? We are almost, on verge of completing 2 decades next year. The Act definitely is of 1999, but it came into force in 2003. To be precise, 15 September 2003, the GI Act was gifted to India. Now, next year we will complete 2 decades, but we are only seeing addition to the list of registered GI. We are not actually realizing, and that is what in the introduction when Ambika was talking about my recent publication, that's all about the about where I have tried to locate the gap between legal rights and real rights, because you already have a right which is granted on paper, but then that right is yet not realized. My research, definitely the empirical research that I have conducted, definitely conveyed that those rights are not reaching to the beneficiaries. So there are certain issues and challenges. What are they if I sum up in this manner? The first and the foremost issue is the enforcement related issue, which is pre and post registration both. Because for pre-registration also, most of the GI tags are granted to those institute or universities or civil society people or government agencies, those who have established that they are working definitely in the interest of these artisans or weavers or producers, right? But then those are coming from such backward area, or they don't have time for the earning their or establishing their legal rights, and that's how they don't take it up. So there is definitely lack of awareness for pre, and once it is granted, that is also something which I could identify as a very important and a huge issue, that those who have been granted these rights are also not aware. So then they cannot take benefit out of it because they don't know that they have these rights. So mass awareness is needed, including customers, right? If you see, just a month ago, I had visited Bhuj, and since I'm working in this area, I visited number of shops and I tried to find out where is the original block print or ajrak which has been applied to the original kind of cotton or silk. And to my complete, you can say, to my complete pain and sadness, I had to notice that very few few are involved in this. Most of them are now going with the digital printing only. Why? Because they are not getting sufficient price for it, and the customers aren't aware, so they don't want to pay so much. So if you are there, they're getting something for a particular cloth, 1 meter for 150 rupees, they are not ready to pay 250 or 350, because original block print or Ajrak definitely is not something which can be made available at this particular cost. So there are number of such issues, mass awareness. So customers aren't aware, right? They were not ready to believe that I'm able to identify that these are digital prints and they are not real hand woven, or they are not real hand block prints. So mass awareness is needed, then branding and marketing. If we talk about other countries like EU, they have excellent system for branding, marketing, and quality maintenance, especially quality maintenance. They do have setting up, mandatory setting up of code of practice, which we do not have. Of course, when we apply for geographical indication, and I am still talking about traditional knowledge protection, friends, I'm not on GI, but how traditional knowledge-based products can be protected through GI, and what are the challenges, that is something which I'm highlighting. So the code of practice, do we have that, or we just do not have? We have it, but it's on paper. When we apply for a geographical indication, at that point of time, the statement of fact is to be applied, which is a form of an application. Their inspection body details are required to be mentioned, but they are just mentioned. Then they are not at all active, and most of the inspection bodies which are mentioned as part of the application for a particular product are completely non-functional, and they are only on paper. So these are various, quality maintenance, branding, and marketing related issues. The policy initiatives and ensuring effective participation of artisan weaver and farmers is the key. We do not have any database. There is no portal which can definitely give you complete information about them. They are unaware. They lack in information and awareness, and that is how they are unable to tap the benefit that they are ensured with on paper. So this is what I thought I will talk to you about, how traditional knowledge can be protected, and how traditional knowledge through geographical indication, not traditional knowledge, but traditional knowledge-based products can be protected with the help of geographical indication system that we have in India. So I think I have stick to my timeline, which has been given, which was half an hour. And thank you very much for the opportunity. Over to you, Ambika and Disha.
Thank you so much, ma'am. We are so glad to host you. And like the logo of GI says, Atulya Bharat Ki Amulya Nidhi. And we have Amulya Nidhi, ma'am, who has justified and beautifully taken us through this journey of understanding traditional knowledge in IP. Thank you so much, ma'am, for being here. And over to you, Disha, ma'am.
Thank you. Thank you so much, Ambika.
Thank you, Nidhi ma'am. Okay, so now it's my honor to invite our next speaker for the day, Dr. Devmita Mondal. It is always a privilege to listen to her. For me, I would introduce the speaker for the day. Ma'am is working at Hidayatullah National Law University since 2015. She teaches intellectual property law specialization papers and information technology laws to graduate and undergraduate students. She has completed her LLM with specialization in IPR from Nalsar Law University, Hyderabad, and is UGC NET JRF qualified. Her areas of interest are intellectual property laws, information technology laws, and changing facets of concept of laws, technology, and justice in society. She had been selected for WIPO full sponsorship in 2019 for participation in second APIRA conference held at Indonesia, and was also awarded full scholarship for workshop on access to medicine, TRIPS, and patent in developing world, co-organized by TIS Mumbai, Third World Network, and Jan Swasthya. She also works as an editor for several peer-reviewed journals in India, and actively delivers lectures in universities, colleges, and IP awareness camps and schools. Apart from this, she also has to her credit various national and international publications in reputed publications in various journals and conferences. We welcome you, ma'am.
Thank you, Desha, for that introduction. And firstly, I would like to thank Nidhi ma'am. It was a wonderful presentation. I was going through, like listening to her presentation, and it was really delightful, ma'am. And also I have attended one of the workshops JNLU had previously conducted on TK. So it's a pleasure to meet you again, ma'am. Thank you so much, ma'am. Now,
Thank you so much. Same here.
Now I'll just share my slide, Disha. Just let me
Sure,
know
ma'am.
if you can see
Yes.
it.
It is visible, ma'am.
Okay. So I'll start. Now, let me clarify first. I'm still pursuing my PhD. Disha said, Dr. Devmita. I was like, okay, that should be done quickly, but then not right now. So this is the topic of my PhD also, my thesis also. It's very similar to my PhD thesis. I'm here talking about analyzing the protection of traditional cultural expressions through copyright laws. So my focus is on copyright law, and I'm talking particularly about, like Nidhi ma'am pointed out, one set of traditional knowledge, that is traditional cultural expression. So it is said that good artists copy, great artists steal. Here we have on slide a picture, which is a scene-by-scene comparison of Beyonce's one of the most famous songs, Spirit from The Lion King. It is a scenic arrangement copy and in fact choreographic arrangement copy also from a sound recording of Peter Noy. And you can see for yourself how the copying has happened. Peter Noy is an artist, it is an indigenous artist, we can say, and kind of his whether this is a copyright infringement or not, that will come to later, but we can see for now there is scene-wise copying happening here. Since my topic is traditional cultural expressions, let's look at what is traditional. How do we define traditional? So Justice Brennan in Mavo versus Queensland, one of the famous Australian judgments, tried to define what is traditional, or how do we determine what is traditional. He talked about when a clan or a group is continued to acknowledge the laws, to observe the customs based on traditions of that clan, whereby their traditional connection with the land has been substantially maintained, the traditional community title of the clan can be said to be remain in existence. So when we talk about traditional cultural expressions, we can always look into how the community or the clan in question is connected to their ancestral lands, to their ancestral traditions, to their ancestral natural resources and practices. Other popular terms which we hear is, it is indigenous, it is tribal, it is Adivasi art. So let's look at who are indigenous people. United States Special Rapporteur Martinez Cobo once said, indigenous communities, peoples, and nations are those which having a historic continuity with pre-evasion and pre-colonial societies. I'll stop here and highlight that unlike traditional, which is just connected to land, resources, communities, practices itself, while defining indigenous, we often have a preset requirement of continuity with pre-invasion or pre-colonial societies, which would mean that in India, we have indigenous people, right? Because in India, there has been evasion happening over decades, over centuries. There has been colonized, we have been colonized by the British Empire for longest period of time. But however, when India voted for the United Nations Declaration on Rights of Indigenous People in 2007, it precisely, the representative precisely denied acceptance of the term indigenous and rather focused on terms like Adivasi or scheduled tribes for India. This is because India believes, because according to this declaration, there is a right of self-determination of the indigenous people. And India being a sovereign nation believes that there cannot be cessation of these groups, these native people of India from the state on their own will. UN, while discussing on indigenous, talks about self-identification, whether these communities are identifying themselves on their own as a part of a clan or a community, a local group or something. It talks about historic continuity. It talks about closeness to natural resources, particularly their ancestral lands and their natural resources. It talks about distinct political, legal, and social institutions of these communities. distinct language perhaps, which can be verbal or verbal and written. So these are some of the facts. Now coming to tribes and tribal people. Who are these tribes? Because we have tribal people of India, right? So if you're talking about traditional cultural expressions, we must be referring to who are tribes or tribal people. Tribes or tribal people, according to ILO, the International Labour Organization, in their convention of 1989, are those whose social, cultural, economic conditions are distinguishable from the dominant society. And they are whether wholly or partially governed by their own customs and traditions. When the National Commission on Scheduled Tribes in India listed the factors for determining which tribe will be recognized officially as a scheduled tribe, they noted factors like primitiveness, geographical isolation, shyness, educational, social, and academic backwardness. Now, let me tell you again, which means that we have tribal people or we have tribal community or tribes in India who are not listed as STs under the Indian Constitution, but who might be locals pre-evasion, pre-colonization of India. They are not in the official list because they may be socially forward now. They may not be geographically isolated anymore. So this is something also we have to keep in mind. Now let's come to the contours of traditional cultural expressions. When we talk about TK in a wide sense, it would mean tradition-based literary work, artistic work, scientific inventions, innovations, all intellectual capabilities of all intellectual works of the community per se. But when we talk about TK in strict sense, it is more connected with scientific inventions and innovations. Whereas genetic resources refers to genetic resources of animals and plants, and traditional cultural expressions are also known as expressions of folklore. They refer to music, art, designs, memes, signs, symbols, performances, ceremonies, architectural forms, handicrafts, narratives. Now that we have looked into what is the contour of TCE, it is important to see an example. This is a picture of Qatar Airlines aeroplane. Qantas Airlines in 2018 developed this livery for their airline along with an indigenously owned design artist studio known as Balaring. Now, when this indigenously owned design studio crafted this livery, they hired Aboriginals of the Torres Strait Islanders of Australia. However, the contract between Qantas Airline and the studio is not open for public negotiation or public viewing or public negotiation. If we look into this is a classic example of how Aboriginal art is bring to global platform because the airline has a global reach. Now, what are the potentials of this act? There can be cultural harm because when we talk about TCEs, some TCEs can be sacred or secret for the community. There can be intellectual property harm because what about the rights of the designers who designed or who artists who drew this kind of art? Were there prior informed consent taken before it being adopted into a livery for the airline's aeroplane? What kind of benefit sharing happened? These are certain questions we have to look into. Now, whenever we talk about TCE, a TCE can be in public domain. It can be widely available in the country, but still widely practiced only by the community. It can be sacred and secret and therefore only limited to the community and only for specified purposes only, specified religious purpose or their cultural practices, whatever so. So when we are looking about protection to the copyright regime, we have to understand that TCE per se might not be protectable. What we are trying to do is we are trying to take help of a private right like copyright and trying to protect the rights of the community through this right so that they have a negative right against society and they have the deciding factor how it will be commercialized or how it will be brought to public. What can be the potential challenges to copyright regime in protecting TCE? In copyright, the right revolves around the author. And we know that generally the author is the first owner of the copyright also of a work. However, in TCE, or when we talk about indigenous communities or tribal communities, their sense of ownership might be very different or different from our understanding of ownership. They have a theme of custodianship where the community has control, or the pradhans of the community has control, and they decide how a particular cultural expression will be utilized, for what purposes to be utilized, who is authorized to utilize that per se. For example, I have a case law from Australia, the Bulun John case. So John Bulun found out that his bark paintings, which are reflection of his communities, Aboriginal communities, dreaming process, has been illegally imported, like illegally manufactured and reproduced as fabric paintings in Indonesia, and thereafter imported to Australia. So he's Aboriginal from Australia, but he finds out that his works has been kind of stolen and taken to Indonesia for fabric prints and then brought back to Australia as fabric material. Here we see an image of magpie geese and water lilies. This is the kind of concept they have, as to folklore they have in their own community, which has been represented by Bulun's own pictorial representation on bark painting, which is now printed on fabric. This kind of fixation on a medium is without the permission. But often what happens here, Bulun was alive when this thing happened, when this case came to front. But often what happens, to establish authorship is a difficult process, because these TCEs might be centuries old. The second challenge which is there is regarding originality. When we talk about copyright, copyright is not, originality doesn't refer to novelty sort of as we understand under patent law, but something which is coming from the author, from the intellectual capability of the author. Now, TCs are not stagnant, or as we say popularly, layman, we understand that it is ancient, therefore it's fixed already, there is no change per se, but that's not how TCs evolve. TCs are constantly evolving within the society as long the society is existent. So they are not deprived from only previous works, but they are based on traditional creations, which is a continuous process. So what if copyright has to protect TCs, or can be an umbrella for protecting TCs, then the artistic license of the community has to be kept into minimum, so that what is copyrightable and what is not copyrightable can be distinguished. But derivatives is a very nature of TCE. Every time, every passing year, the TCEs of a community are developing, or further derivatives are being made in an authorized fashion. So that's how originality becomes a challenge for protection of TCEs. Then we have fixation as a challenge. So fixation determines the boundaries of what is protectable under copyright law. Many of the communities, in fact, we also believe that there's a process called dreaming, or where a person is in trance and he realizes things. So folklores are often conveyed. It is a popular belief among traditional communities that folklores are often told or passed from one generation to another through revelations, ancestral revelations. So traditional secrets are passed, ancestral stories are passed. Now, dreaming as a process cannot. So if I dream about something as an indigenous member of a community, my dreaming's representation will be different from another person's. So fixation is often also not done. These are orally passed, or these are through a trance that it is revealed to me. I cannot prove that there is a document which my forefather gave to me, and therefore there is a proof of ownership per se. This is another challenge. Like ma'am said, there is benefit of documentation. So these communities can always come forward, like we have the TKDL, they can come forward and list their traditional cultural practices per se. But the ambit of such expressions as such use, it's difficult for the communities, even for the communities to come and list out what are their cultural expressions. because it's a part of their lifestyle itself. Next point is regarding duration. Copyright is a limited right. It's for a fixed period of time. But these communities are continuously evolving and they're continuously keeping on creating new forms of cultural expressions. For example, when there's a restricted park in Australia, which is restricted for public viewing, which has rock paintings like we have in Ajanta Ellora, they also have rock paintings on caves and the rock per se, the hills per se. These paintings were reproduced in t-shirts and sold for mere $30, for $30 per se. But this copying from the, even when there's a fixation, copying from the rock surface to a t-shirt is a reproduction of the artistic paintings or drawings or sculptures per se. Now, these rock paintings, like, even though they knew which is the community, Mimi was the community. So even then they knew these paintings are by Mimi community, but the community could not be tracked back to, or where, when the work has been done, that cannot be determined per se. Now, if that cannot be determined, then the period of copyright also cannot be determined. So who will enforce the copyright? This is the classic case when anthropologist and his wife, Brandel, came forward and they showed photographs of these caves, and they said, if we hold the copyright, then we as a custodian for the community are asking these reproductions to be stopped. And here I have a drawing of the how Mimi community arts look like. They're thin human representations on caves per se. Next challenge is regarding enforcement of rights. Now, in today's economy, there is a term called inspiration. I'm inspired by, I have not copied, I have not stolen, I have not plagiarized. I'm rather inspired by the idea of someone else. But this inspiration can often lead to misappropriation of TCEs. So even if under the copyright realm, we have two kinds of rights, economic rights and moral rights. The economic rights cannot help when the author is claiming that my work is just an inspiration. Classic example again, there is a Mizi tribe from Mexico. They had these traditional blouse designs. They are indigenous people from Mexico. So their blouse designs, which generally cost in Mexico around 300 pesos, was copied by Isabel Marant, a French designer, who sold the same blouse for 4,500 Mexican pesos. And there was a newspaper article also where the French government, there was an article titled that the French government will in future sue these communities from reproducing because it is the copyright of Isabel per se. So even though in the interview process, Isabel said that these are inspirations I got and therefore it's her original creation, but such inspirations can also lead to violation of copyright per se. Now let's come to the Indian copyright law and TCEs of India. We have the term tribal, but I told you the problem with the term tribal also, because there are scheduled tribes within the concept of scheduled tribes. Many tribes of India are not listed. And if we take per se the term, any other term like traditional, then everything, like even my family heritage is a traditional cultural heritage there. So it becomes a distinct problem specific to India itself. However, it is interesting to note that there is no mention of tribal or indigenous people or traditional knowledge in any of the IP legislations as a right, but there is a defensive protection under patent law per se for traditional knowledge. Now, if we refer to the Copyright Act per se, the Copyright Act of 1957, which was amended in 2012, and its ambit per se, the concept of ownership there is based on author. And it is primarily single author, and there can be works of joint authorship also, but there is no concept of communally owned. Parallelly, I was drawing a comparison. In Australia, there is something called communal ownership, and they have communal moral rights also. Our concept of authorship is primarily under section 17 and thereafter, it is primarily joint authorship and individual authorship. So this can be a flaw, how traditional folklores of India might not be protected when it is communally owned. Unless it is shown that the author per se has a fiduciary relationship and the author is suing for such infringement, TCEs might not be protected under the concept of, under the realm of Copyright Act in India. Now coming to the rights, when we talk about the economic rights, these are exclusive rights of the owner of the copyright. These rights are negative in nature, and these rights are useful only when the communities come to forefront for commercialization. But if they're more concerned with protection, with preservation, then these rights fall short of, because they can just exclude their defensive protection, and they cannot be used for preservation or protection per se. Term of protection against, again, I told you, it's life of author plus 60 or 60 years from the date of publication. It becomes a problem because we need these protections to be forever or perpetual. Now, interestingly, India, during the Tunis model of development of negotiation on TCEs, did vote for a perpetual copyright or a perpetual period of IP protection, but that kind of sui generis legislation is not existent in India right now. Now we'll come to moral rights of authors and performers. Let me illustrate through some examples. So for example, you must have heard about in the newspaper about Badshah's song, like one of the songs with Jacqueline. Now, this song had a line, Borlokir Biti, which is from a Bengali folklore. Now, the author of the folklore, who has written the lyrics and who sings and performs it, is still alive. Still, Badshah went on, and initially he did not even cite that it is a part of Bengali folklore, but later, after a public hue and cry, he has termed it as traditional folklore of Bengal. However, the author is not credited. He was given a minimal amount of money. So how copyright can help is that copyright in such scenarios can empower the author to file a case of infringement to stop such bullies or corporate bullies from taking benefit of their work without due recognition and due payment through economic right and moral rights regime. There is another unique problem in India that we can say that works are, like Nidhi ma'am also said, that the Ajrak works are not being made through the block printing process, but they are digitally being printed. Similarly, lots of handicrafts in India, which are copy or which are reproducing the traditional cultural expressions, are being prepared without authorization and are being sold for cheap on e-commerce platforms. So I have given a picture here. This is from the Theam headdress. So Theam is a kind of rough kind of dancing by the Dalit communities in Kerala, and the headdress which they wear have become commodified by unauthorized people. So these headdresses are works of artistic craftsmanship. They can be protected if these communities come forward and claim copyright protection over each of the headdresses which are designed. Another example is adoption of the Warli painting on chappals. Warli paintings are generally done by women, and they are done for auspicious occasions like marriages, religious ceremonies. They were adopted, like they were printed on digitally on Bata chappals in 2018. Again, Bata faced a human public cry where they were criticized, and finally they took down the product. But these are also issues where if the art can be protected through copyright, then because there are Warli painters who are very famous in India right now, who are having international acclaims of their work. So if they come forward and as a custodian of their community file copyright infringements, then these works can be prevented from commercialization and commodification. Now, coming to a conclusion, how copyright can be a solution. Whenever we look into the national legislation, because copyright is a territorial right, when we look into this national legislation of each country, we have to see that whether there is a reference to folklore. And if there is a there is no reference to folklore, does it amount to exclusion or protection, or are there other sui generis legislations like GI, like any other traditional laws which they have, which is already granting such protection? If there is an explicit exclusion, still such work can be protected under copyright regime through the public paying domain. Even if the work has entered public domain, royalty can be charged for maintenance, which can be collected by the state or by an association of the community and used for the maintaining the livelihood of the community per se. In certain countries, of course, copyright is purely, TCs are purely excluded from copyright protection. And even in countries where there is a mention of folklore, there can be either direct protection, so the state owns, like there are countries where it is like Indonesia, where the state owns the copyright over all TCs, all the cultural properties are held on behalf of the state itself. So they have the right to enforce such rights. Or it can be through indirect protection through neighboring rights regime also of the copyright. So not direct copyright, proper copyright, but through the neighboring rights regime per se. So this is how copyright regime can be used as a tool for upholding and preserving the rights of communities which are either traditional, local, native, aboriginal, whichever term you want to use it. Thank you.
Thank you, ma'am. It was really very informative and enriching. I don't know. I only take this subject in the classes these days, and I couldn't have ever done this justice for like the way you have explained it. Thank you so much. Okay, so I would now request students to ask any doubts, any questions, if any. You can raise your hands or put up the questions in the chat box. Yes. Okay, so ma'am, we have a question from Akansha. I guess this is open to both the speakers. In your opinion, how inclusive GI is of traditional knowledge, and do we need a more expansive law for traditional knowledge?
I think Nidhi ma'am is not here. Disha?
Yes, ma'am. Yes, ma'am.
Should I address it?
Yes, yes, sure, ma'am, please.
Okay, so how inclusive GI is of traditional knowledge. Now, let's say if you have listened to Nidhi ma'am, she was highlighting some of the features like GI is not owned by, like it's not owned by, or there is not a proprietor of a single person as proprietor. The concept is the community has to come forward and they have to also show, when a community is filing for it, whether a society or any board which is filing for it, they have to show that they're connected with that particular art and craft. If it is a handicraft, if we are talking about traditional knowledge in the sense of, let's say, process per se, it might not be coming under the GI ambit itself. And if it is a natural resource, then it might be a natural product. Maybe the traditional community's knowledge is embodied per se. So one thing, there are two kinds of rights which is there. The GI rights are not transferable from it is only transferable according to in a linear fashion from our ancestor to another what is the term for it, like from my father to me. So it can be heredited and it cannot be transferred outside per se. I cannot transfer to my friend per se. So in that way, it is hereditary, just like traditional knowledge, which is passed from generation to generation within the community itself. So these are features which enable GI to be a tool of protection. Now, do we need a more expensive law? Yes, we definitely need a more expensive law. In fact, we need a sui generis law. These GI or copyright or patent per se can only act as, and as far as I feel, it can only act as a defensive mechanism. For positive protection, we need a separate act or a sui generis law on traditional knowledge. Now, there are many loopholes, like how will the benefit sharing work out? How will the negotiations work out? Because those provisions are also under the Biodiversity Act, and those are already being criticized. There are newspaper articles on how the consent is not taken. It's not a fair consent. It's not a fair term of negotiation. So the same can happen even with the sui generis law on traditional knowledge. We have to be careful, but we are in need of a traditional knowledge law specific sui generis legislation of the same.
Thank you, ma'am. We have another two questions, I guess. Can the IP laws? Okay, I guess this is answered. Okay, so ma'am, we have another question. How should we preserve indigenous knowledge and traditional indigenous knowledge? Like, are they the same, traditional indigenous knowledge?
Okay, so that was a theme I took up in the first part. Like when you talk about traditional, traditional can be anything which is connected based on tradition. Okay. When we talk about indigenous, the term indigenous itself requires that these are pre-existing people recognized by the state who were existing before either evasion in that particular territory or colonization. So in a way, you can say that all indigenous knowledges can come within the broad ambit of traditional knowledge, but traditional knowledge is vast, particularly for India. Like if you see, traditional knowledge can be knowledge from the SC, ST, from even normal people, general category. General category people also have their cultural expressions, right? They are also cultural expression, traditional cultural expressions of India. So in that way, all kinds of traditional knowledge is a very wide ambit, whereas indigenous knowledge in its very definition, its very interpretation is limited to pre-colonization people or pre-evasion people, natives of that country. Now, how do we preserve such knowledge? There are many kind of legislations, like in many countries like New Zealand and Australia, it's the traditional laws which has been adopted at national level and made part of the national legislation. So the determination factor or the determination will of these Aboriginal have been recognized at international at the national platform itself. There are countries like Indonesia and all where the state is a kind of guardian of this because they believe these communities are primitive, they are not aware of the modern systems, so they act as a guardian. So the state negotiates and state ensures that there is protection per se. Now that also has a problem because state might be partial in its approach per se or in its way of guardianship. State might think something is a national heritage and doesn't need to be commodified, but there is a potential of benefiting the community, which is not being done only because the state believes it's a national heritage. So there are many kinds of regimes which are already in existence in different parts of the world. Now that we are looking, also there is a TKDL bill in India which talks about, which was introduced way back and which also talks about custodianship. So India also, like the other South Asian countries, believes in state being custodian on behalf, like state being the facilitator who will on behalf of the tribes or indigenous people negotiate these deals. So that's one approach which was pre-existing there in India. But I think and I believe that it should be more involved process where the communities itself have their own saying, very similar to what is in existence in New Zealand, Australia, because they have huge population of Aboriginals and their Aboriginals are very well protected.
Thank you, ma'am. Thank you for all the answers, answering all the questions. I guess Nidhi ma'am is not here. Fine. So, Namita ma'am. Ma'am, you're on mute. Namita ma'am, you're muted.
Yes, Disha ma'am. I'm raising my hand.
Yes.
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 I apologize, ma'am. I am our guest speaker, ma'am. I'm apologize just a little bit busy in some academic and administrative work. So I was not, in starting I was not able to attend, but afterwards I attended your session and that was quite informative actually. And thank you very much, ma'am, for just accepting the offer. Just like an opportunity to listen you, ma'am. So thank you very much, ma'am.
Thank you so much, ma'am, for inviting me.
Thank you, Devita ma'am. It was really a pleasure listening to you and Nidhi ma'am both. We look forward for more such sessions from you and also Nidhi ma'am. So I
Disha ma'am, that why don't you calling her as an it's physical? Why she in the offline mode? Then she told me, yeah, you are quite busy and it's not possible to be in the offline mode.
ma'am, Devmita ma'am is a new mom right now. So I guess that she will not be able to see us physically for some days more. Maybe in the next session or next semester, we would be calling Devmita ma'am offline, ma'am.
Sure.
I'll be available soon, Disha. My holidays are over.
Okay, ma'am. Thank you so much, ma'am. I guess that it's already time, so we will close this session. Thank you so
Thank
much,
you for
Devmita ma'am.
inviting me. Thank you.
Yes, ma'am. Thank you.
So we can close the session.